If you are applying for a green card in 2026 and you are still using the playbook from 2025, I am sorry to tell you, you are not even in the game. So much has changed and will change when it comes to the green card application process, especially the marriage-based green card application process in the United States. In this video, I'll be breaking down what has remained the same, what did change, and what will change in the future. I am attorney Lilian Chukwurah, and in my immigration practice, I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. And one thing I can tell you is that that system is changing and changing rapidly. Let's talk about what hasn't changed when it comes to a marriage-based green card application. The forms have not changed, okay? You still need an I-130, an I-130A, an I-485, an I-864, and an I-693. You still need all of those things to properly file a marriage-based application. Those are the forms you need. The required documents still has not changed. You still need your marriage certificate, proof of your relationship, birth certificate, passport, proof of your entry. All those things has not changed. As of the recording of this video, the forms have not changed, but in the next section, we'll talk about one of the forms that will be changing. Although the forms have not changed, the way USCIS processes the application, reviews your eligibility, and conducts the interview has changed. So we'll be talking about that next. So the forms are still the same as of the recording of this video. Another thing that has not changed is that you still have to prove that your marriage is real and you entered into it for love and to build a future together and not for immigration benefits. So what does this mean? You need to still make sure that you're showing joint assets, joint responsibilities, that you're living together, that you're building a life together. USCIS is still looking for those things. So make sure that you are gathering those evidence for your case. For all adjustment of status applications, you still have to prove that you either entered the U.S. with inspection or with parole. And this means you entered with a visa and that visa type that you had is able to adjust status. There are certain visa types that cannot adjust status in the U.S. So you need to make sure that you have the right visa type when you entered. You had parole and that parole is eligible for adjustment of status. Again, depending on the type of parole, it may not be. So you want to be clear on that. So that is still a requirement. It was a requirement before. It's still a requirement now. You still need to prove that you have enough income to support the person that you're sponsoring, or you need to have a joint sponsor for your application or have enough assets to meet the income requirement for sponsorship. Now let's talk about what has changed and what will change in the future. The biggest change that has happened to the green card process is literally the changing of how officers evaluate adjustment of status applications. So before, you could meet the requirements for adjustment of status, you apply and you get adjusted status. Now, there's a new policy memo that was issued on May 21st, 2026 that basically says adjustment of status is an extraordinary benefit. So with adjustment of status now, with this new memo, making adjustment of status an extraordinary benefit, you are basically having to prove to an officer that you merit that extraordinary benefit of adjustment of status. So just because you're married to a U.S. citizen, just because you meet all the requirements for adjustment of status, does not mean that an officer is going to approve your adjustment of status application. You still have to meet certain requirements. Basically, with this new policy, what the officer is trying to gauge is that, is there any good reason that you are choosing adjustment of status over consular processing? There is multiple factors that go into this, but I will tell you with real world experience that I have had interviews where officers ask questions that specifically go to this issue. So this is stuff that is happening at interviews. So you need to be aware of it. People are being denied because of it. So you need to be aware and know how to answer these questions, okay? I'm going to go through kind of the type of questions you may get that an officer is really trying to gauge whether you merit this extraordinary benefit. So one of the biggest ones is, do you have any properties, investments, or businesses in the United States? Again, this is showing your investment into the US because you bought a property, you are invested in the US economy, you are basically creating economy where you are. So they're looking at what is your investment into the United States. That's what that question goes to. Then there's also a question about community involvement. How involved are you in your community? Do you volunteer? Do you, coach basketball? Do you do anything in your community? And let me tell you something. Church counts, okay? To those that are like, oh, but I'm not volunteering at the YWCA, or do you volunteer at your church, right? Are you doing Bible study for youths, right? Are you volunteering at Vacation Bible School? That counts as your community involvement. So you want to really think about all the ways that you are involved in your community and you want to list them. Next up, you want to talk about your skills, right? Do you have a certain level of education? Do you have any skills that you have built over the time that you've been in the US? Those are very helpful. And remember, on the I-485, there is another section that asks about any special skills, certifications, or anything like that that you may have. You want to list them all. It doesn't matter if it's like something that you don't consider a major skill. Put it there, okay? You know how to sew? Put it there. You do arts and crafts? Put it there. Whatever your skill is, right? You know how to code? Put it there. Those are things that the officer is looking at for your development in the US and how you're going to benefit the US. Remember, that's the frame we want to use for all of this, is how can you, adjusting your status, benefit the US? That's how I'm framing it in my mind when I think about it for clients. And then officers sometimes ask about family. Like, do you have any family in the US? Do those family members have any medical conditions that you're helping them with? Those are things that, again, show your ties to the US and why you may choose adjustment of status over consular processing. And some officers do come right out and ask you, why did you choose consular processing over adjustment of status? And you better have a good answer to that. Not because, oh, my lawyer told me that I could. Yes, but why did you choose it, right? Why was that even an option if you could consular process? And in most situations, for clients that have been in the US for multiple years that have overstayed a visa, adjustment of status may be a better option for them than consular processing, because once you leave the US, after 180 days of overstay or a year of overstay, you're looking at a 3 or 10-year bar before you can even apply for consular processing to get a visa to the US. So that could be a factor in that determination. Another factor may be the fact that maybe your country doesn't have an open embassy and it is taking 3 years for people to get interviews at a different embassy altogether. Again, these are things that can affect your decision to consular process versus adjustment of status. The thing to keep in mind with this extraordinary benefit, again, is the framing. You want to show how you have grown as a person in the US, how your presence in the US will benefit the United States in some way. And that can be in your community itself. So don't feel like it has to be this massive thing that you're doing that's so important to the national security of the United States. No, it may just be that you have created a program in your community that is helping, underserved communities. That could be the thing, right? You are volunteering at Boys and Girls Club. That could be the thing. So be sure to highlight all the amazing things that you are doing in your community. Another thing that has not changed yet, but will on September 18, is the public charge rule. So Under the Biden administration, there was a policy memo in 2022 all about the public charge rule, how the officers are supposed to apply certain evaluations. So for example, if you had any sort of public benefit, there's only certain types of public benefits that can be used against you when you are applying for adjustment of status. This memo takes that away. So it basically says the officer can consider any public benefit you receive. They do not have to look at it in the full picture. They can just deny it based on the fact that you got that public benefit and the officer believes that you will be a public charge. Now, how do you combat this? By showing, one, that your sponsor has more than enough income, okay? And then two, by showing that you yourself, if you had the ability to work in the United States, were working or are currently working. Those are things that can help you in this whole process. With this change on how the public charge rule is going to be applied, comes another change that you can expect on September 18th, which is the form I-485 will be updated. So they will update the form I-485 to add more questions that goes towards the public charge rule. It was changed to only include the questions that officers are allowed to consider. Now it's going to be more questions. We don't know what all those questions are going to be, but once the form is published, I will do a full deep dive with you so that we can talk about what the changes are, compare the two forms, and see what they are trying to get to, okay? But just know, if you are filing your application on or after September 18, 2026, honey, be sure that you are using the most current forms. Every time I file an application in my office, before it leaves the door, I'm checking the edition version to make sure that I am filing the most current edition according to the USCIS website, okay? Make sure that you are using the most current edition and that you are getting that from the USCIS website, okay? Not a third-party website, USCIS website. By the way, if you are getting value out of this video so far, please make sure that you hit that like button, share this video with anyone you know that are going through their own immigration journey so that they understand what is the same and what has changed. And finally, USCIS is trying to move to more an electronic filing. There is an interim final rule that basically says that USCIS can require you to file your application online if that form has been available for online filing for 180 days and the USCIS gives the public 60-day notice of their decision to make it mandatory. Then you must file your application online. So you need to pay attention. Again, that's why USCIS website is my go-to before I file anything, because I need to know what I can do and if there is a specific filing requirement that I need to follow. So if there is a rule that comes out and says that a specific form must be filed online and they follow the process of having the form available for online filing for 180 days and given a 60-day notice, I will let you know, because guess what? I don't want you to be out there filing on paper and getting your application rejected, okay? Now, there is an exception to that rule. So if USCIS follows all the requirements and makes a form mandatory for online filing, you can file a form to basically request a waiver if you can show that you have a hardship. And that's why you can't file online. If you are working with an attorney, the chances of you getting that waiver is like 0. Okay, it is 0 because your attorney should be helping you to make sure that you get it done. So that's how USCIS is thinking about it, right? If you're filing on your own and you're not able to file online, you need to file this form first, get the approval, and then you can file on paper. There is a fee for this form. The form is $25. And if you're doing a marriage-based green card application, remember you're including an I-130, an I-130A, an I-485, an I-864. If all of those forms have a mandatory online filing, you will need to pay that $25 to request the waiver for each of those forms. Now, what I have been pushing for my clients is just to file online, because you get your receipt number almost instantly, and you get to save $50 on each application fee. So I am definitely encouraging my clients to file online. I just recently found out, if you did not know this, To my lawyer friends out there, if you do not know this, something that I recently found out while I was doing research for this video to see which forms are already available for online filing is that if you're filing a marriage-based application and you're doing a concurrent filing, meaning that you are doing the I-130 and the I-485 filing at the same time, you can actually do it both online if you're working with an attorney. Unfortunately, it is only available in the representative portal when it comes to doing a concurrent filing. So if you're doing an I-130 and an I-485 together, and you do not have an attorney or representative assisting you with that application, you still have to mail it into USCIS. Unfortunately, they may update that eventually, but for right now, only attorneys and representatives are able to actually get you filed online for a concurrent marriage-based application. I will definitely be testing that out with my next marriage-based green card application because I think it's such a good opportunity for my clients to file online, get their receipt notice fairly quickly, and also get a $50 reduction in fees. Listen, the filing fees are expensive. Lawyer fees are money. So I want to make sure that if I'm able to save my clients $50 per form that they have to pay for, I'm going to save them that $50, okay? It may be more work to file it online, but I will get through that work to make sure that they get that discount. I want to cap this video by saying this, and I've always kind of said this in my videos when it comes to marriage-based green card applications, but now more than ever, this statement is true. Your interview is more important than you ever thought before, okay? Right now, all marriage-based green card applications are getting an interview. The days of the interview waivers are over. I've had potential clients reach out to me asking me, what are the chances of our interview being waived? And I told them 0% chance because marriage-based green card applications, that initial application is going to have an interview. Marriage-based I-751 removal of conditions when you're going from a 2-year card to a 10-year card, those are getting the interviews waived. But for marriage-based applications, for that initial 2-year or 10-year card, you are going to have an interview. And in that interview, you really have to be ready to answer those questions that we talked about when it comes to the extraordinary benefit of an adjustment of status. You have to be prepared for that. So make sure that you are preparing for your interview, that you are ready to answer those questions at your interview. Another thing that has changed in the marriage-based green card application process is that USCIS is now not required and most likely will not be sending requests for evidence for initial evidence, okay? Your application needs to be solid and acceptable when you file it, meaning you need to make sure that you follow the USCIS instructions to the T to make sure that every single form, every single document that is required for your application is included in that initial filing. Because guess what? USCIS is basically saying if they find that you did not include those initial documents, they are going to deny your case. The officers are no longer encouraged to send a request for evidence. They can just go ahead and deny the case because the evidence is not there. So now more than ever, having a strong packet, making sure you are checking the boxes on every single requirement and including everything that's required for a marriage-based application with your initial filing is more important than ever because, again, if USCIS accepts the application and then finds out, oh wait, you are missing this thing that we put in the instructions that you need to include, but you didn't include it, guess what's going to happen? They can deny that application and you can start over, but now you have to pay the fees all over again. So to avoid a denial and paying the fees all over again, you want to make sure that you are checking off all the boxes when it comes to that initial packet. So if you get nothing else out of this video, just know the marriage-based green card process is now harder than it has ever been. I have been practicing for 11 years, and I can tell you this is the hardest it has been for my clients getting a green card. So if you are going through your process and you would like a review of your packet before you file it, making sure you're checking off all those boxes. You would like to have us prepare your packet so that you make sure that all those boxes are checked and you can hold us accountable for those boxes not being checked. You can do that as well. And then if you want us to actually represent you from beginning to end on your case, you can choose. That's one of my favorite things about owning a law firm, is that I get to choose the offer that we are presenting to our clients, because you may only need a review. You may only need us to prepare the packet and then you take over the case from there. Or you may want us to do everything for you because you're busy, you're not sure what you're doing, and you don't want to get it wrong. So in those situations, like, I have people that come to me that fit different things. So it's not a one size fit all. Like, not everyone is going to need a full service representation, and not everyone's case is going to fit into just a review. I will recommend what I think would be best for you, but it is still up to you. If you would like to take advantage of any of these three options, the review, the preparation, or the full service, you can do that. Go to my website, lilylegal.com, click on contact us, send us an email, or schedule a time for us to talk about your situation and figure out which option is best for you and how we can help you with your journey. Like I said, more important than ever, your packet, your interview, all of those things are so important. So you want to make sure that you are taking the steps to make it as strong as possible.